In the last class, we had started with bonus shares and rights issue. We had studied what do you mean by bonus shares and what do you mean by rights issue. So we shall be now studying the distinction between bonus share and rights issue. Bonus shares may be made available for the existing shareholders and not for the employees. Rights issue and bonus shares are not the same. There is difference between the two. Under the rights issue, the existing shareholders are given preference over the outsiders to subscribe for the shares of the company, and they have to pay to the company as per the terms of the issue. However, in bonus issue, shares are allotted to the existing shareholders without actually taking any payment from them. So, what is the basic difference between bonus shares and rights issue is, in bonus shares, the shares are freely given to the existing shareholders, and they are not supposed to pay anything for the shares. But in the case of rights issue, they are given to the existing shareholders, but they are supposed to pay to the company whatever are the terms and conditions decided by the company. They can be given at a lower cost, or they can be given at a cost at which they had earlier purchased their shares, depending upon the company, that on what terms or on what issue the company decides to give these shares. However, in bonus shares, shares are allotted to the existing shareholders without actually taking any payment from them. This is done because here the payment of shares is deemed to be recovered by the company out of the reserves or the distributable profits of the company. That means in such a case, the shareholders are given a share in profit, not as dividend but as shares. Hence, one can say that the issue of bonus shares involves capitalization of profits or reserve. So, in bonus shares, we see that it is also called as capitalization of profits, because instead of giving higher dividend, the company decides to convert this dividend into shares or into capital for the company. So, instead of giving higher dividend, they say that they shall give bonus shares to the company, bonus shares to the shareholders by the company. Hence, one can say that the issue of bonus shares involves capitalization of profits or reserves. It is to be noted that the articles must have authorized such an issue. The bonus shares can also be issued out of securities premium amount as per section 52 of the act, and out of capital redemption reserve account section 55. So the bonus shares can be issued out of capital redemption reserve account, and also from the securities premium account. These two accounts are created by the company for the purpose of accumulating the excess capital over the price which is issued by the company. Then next we have debentures, conversion of debentures into shares. Now after the issue of bonus shares, now next we have is conversion of debentures into shares. So how do we convert the debentures into shares? A company may issue debentures with an option to convert into shares wholly or partly at the time of redemption, but cannot issue debentures with voting rights. On issue of debentures, the company has to create a debenture redemption reserve account. The company shall not issue prospectus to more than 500 persons without appointing a debenture trustee. The duty of the debenture trustee is to protect the debenture holders and redress their grievances. So, a company can issue debentures, and it has an option of getting converted into shares. By shares, it means that it shall be converted only and only into equity shares. No other shares it can be converted. So, they can be converted either wholly, means all the shares which are owned, or partly. So, a debenture holder gets the right to saying that he can either convert half of his shares into shares, half of his debentures into shares, or he can convert the remaining part, whatever the remaining shares are, he can get the money from that. Once a company decides to give debenture, they have to create an account saying debenture redemption reserve account. Means what? That this account shall be used for paying back all the debentures which are held by them. And the company shall not issue prospectus for more than 500 persons if the company does not have a debenture trustee. Who is a debenture trustee? Debenture trustee is a person who takes care of the debenture holders, or he protects the interest of the debenture holders, and he helps them in solving all the problems related to debentures, or in case they have any problems related to the company. Next, we have conversion of debentures and loans into shares. Section 63 3. Section 62(3). Conversion of loan or debentures into shares can be done if there is such a term in loan agreement or issue of debentures, if it is approved in the general meeting by a special resolution. So, conversion of debentures and loans into shares. This can be done if there is an provision or if there is a special resolution approved by the company in the general meeting stating that whatever debentures or loans are there by the company, taken by the company, can be converted into equity shares. Remember, anything which is getting converted into shares shall be only and only equity shares. It cannot be converted into preference shares. So, it can be done on a long-term agreement or on issue of debentures. There shall be an agreement between the company and the shareholder or the debenture holder stating that the debentures shall be converted into equity shares after a certain specified time. Then next we have compulsory conversion of debentures into shares. Compulsory conversion of debentures or loan into equity by central government is possible if that the government considers it necessary to do so in public interest on such terms decided by the government. If such terms and conditions are not acceptable to the company, it may file for an appeal to the tribunal within 60 days. So, this compulsory conversion of debentures into shares. It is not compulsory to convert debentures into shares or debentures in loan into equity. If in case the central government feels that it is important or it is necessary to convert these debentures into shares, then they can compulsorily make the companies do so. And if in case the company does not agree with the same, then in that case the tribunal shall within 60 days apply to the tribunal and stating a proper reason that why they don't want such compulsory conversion. It shall be stated to the tribunal. If tribunal accepts or if tribunal feels that the reasons given by the company are valid, in that case debenture holder or the company gets a right to not convert them. But if they feel that the central government has done it out of compulsion, or if they have done it out of some reason, then in that case tribunal has the right to make it compulsory for the company for conversion. Next, after this we have global depository receipts. This new section provides that a company may issue global depository receipts in any foreign country in the prescribed manner subject to certain prescribed conditions. A GDR is a depository receipt or a certificate denominated in dollar or euro which represents the underlying ordinary shares or foreign currency convertible bonds of the issuing Indian company. So, what are global depository receipts? This is a new section which is introduced for us, and it is prescribed by a foreign country. And these receipts are receipts which are used in the foreign company for an Indian company. So these receipts shall be traded in the international markets, and the foreign investors who can raise the capital through foreign overseas, that is through foreign companies, and they can be investors in the Indian markets also. Generally, these receipts or certificates are given in either dollars or euros, which are not ordinarily seen in Indian markets. The GDRs are issued to foreign investors in foreign countries to raise capital from overseas. GDR of Indian companies are listed and traded in international stock market. In US and Europe, such GDRs are frequently issued. Indian companies in many instances have issued GDRs in the past. GDR is defined in section 244 as any instrument in the form of a depository receipt by whatever name called, created by a foreign depository outside India and authorized by a company making an issue of such depository receipts. GDRs can be issued only after it is approved by special resolution, subject to fulfillment of conditions of the new act and guidelines and regulations of SEBI and RBI. So, global depository receipt is an instrument which can be seen in the markets outside India, and the company has authority, or the companies which are listed with Indian Stock Exchange only have the right to get listed in the international stock market, and they can trade their receipts in the foreign countries also, and these are issued by passing a special resolution in the company, and all the guidelines are to be followed which are mentioned by SEBI and RBI. Next, after this, we have Indian depository receipt. First we had global depository receipts, now we have Indian depository receipts. IDR means any instrument in the form of depository receipts created by domestic depository in India, authorized by a company incorporated outside India, making an issue of such depository receipts. IDRs are issued by foreign companies in India representing the underlying security of the issuing foreign company to raise the capital from the Indian market. IDRs can be listed in India and traded in rupees. Offer of Indian depository receipts. Central government is empowered to make rules applicable for an offer of Indian depository receipts. The requirement of disclosures in prospectus or letter of offer issued in connection with Indian depository receipt. The manner in which the idea shall be dealt with in a depository mode by custodian and underwriters. The manner of sale, transfer, and transmission of ideas by a company incorporated or to be incorporated outside India. Whether the company has or has not established or will not establish any place of business in India. So, IDR means any receipt in the form of depository receipts created by domestic depository in India, authorized by a company incorporated outside India, making an issue of such depository receipts. So these IDRs are representing the foreign companies and in the Indian markets. So in case a person wants to invest into a foreign company who is in India, he can purchase Indian depository receipts. But for purchasing these Indian depository receipts, rules and regulations are specified by the central government. Firstly, an offer of Indian depository receipt has to be made. Then the requirement of disclosures in prospectus or letter of offer issued in connection with Indian depository receipt. All the rules and regulations which are stated by the Companies Act and the tribunal have to be shown or have to be fulfilled by the company, and stating that all the rules and regulations which are stated have been taken care of. Then the manner in which the ideas shall be dealt in a depository mode and by custodian and underwriters. The manner of sale and transfer or transmission of shares also shall be taken care and seen to it that if a company is incorporated or has a place of business outside India, and whether it has a proper idea of having the business or the company working, whatever details are to be specified shall be specified in before signing for the Indian depository receipt. Standard Chartered PLC is the first global company to file for an issue of IDRs in India. So the Standard Chartered PLC is one of the global company to file an issue for IDRs. Next, issue of shares for consideration of cash, section 62(1)(c). Issue of shares to others for consideration of cash or other than cash is possible if it is determined by registered valuer and if the issue is authorized by a special resolution. However, in exceptional situations, the company may not be under obligation to offer further issue of shares to the existing shareholders. That means directors can dispose of the shares of such fresh issue according to their discretion, but for this special resolution must have been passed in a general meeting stating that the shares need not be offered to the existing equity shareholders. Means what? In case the shares shares are issued for consideration of cash or other than cash, then the price is determined by the registered valuer, and a issue is passed by passing a special resolution by the authorities. So in exceptional situation, company may give this offer of taking something other than cash. Suppose they have taken some assets, or suppose they are purchasing a land. So in that case, shares can be issued instead of giving cash. So only equity shares need to be offered, and in the general meeting, specified valuer or the registered valuer shall remove the valuation of the asset and then dispose of whatever are the fresh issue or whatever shares are to be given by the company. Next, we have issue of sweat equity shares. Now, what is sweat equity share? Sweat equity share is a reward for hard work done by using intellectual property for benefit of the company. So, what does this mean? That suppose the employees or the people who are working into the company have done something which is unique, or which is something uh, that is done by the laborers, and it has a benefit, or it is done for by using intellectual property, such as gaining a patent, or gaining a patent, copyright, or something like that. Sweat equity is a reward for hard work done or using intellectual property for benefit of the company. The dictionary meaning of the term sweat equity is financial equity created in property by the owner's a laborer in improving property. Sometimes an employee through his work gets certain intellectual property rights, such as patents, copyrights, etc. In such a case, company may offer him equity shares instead of reimbursing such person financially. This strategy is generally used by a relatively new company who are unable to give reward in cash to the employee for his intellectual work or property. The term sweat equity is used as it is earned by sweat, that is hard work by employees, and hence with this incentive to the employees, it is sweat for them. Equity shares means such equity shares are issued by a company to its directors or employees at a discount or for a consideration other than cash, for their providing know-how or making available rights in the nature of intellectual rights or value additions by whatever name called. So, sweat equity is something that is given for the hard work that an employee has put up for the company. This is generally done by new companies who are unable to give rewards to their employees in the form of cash. So, they instead of that they give sweat equity. So, by sweat equity they mean equity shares are given, which is given for the hard work that they have done, and it can be issued at the discount or for consideration other than cash. So it is right in the nature of intellectual value, or it is for the intelligence or for the creativity that a employee or a laborer has used. This is a way of creating motivation among the employees of for bringing new ideas or getting new things into the working. Here, in this case, consideration given by employee to get these shares is not cash or not money, but it is in the form of intellectual property like patents, copyrights, etc. So, this is for given for consideration by employee to get these shares not in the form of cash or money, but in the form of intellectual property like patents, copyrights, etc. According to Section 54 of the Companies Act 2013, a company can issue sweat equity shares of a class of shares already issued if the following conditions are fulfilled. Namely, the issue is authorized by a special resolution passed by the company. The resolution specifies the number of shares, the current market price, consideration, if any, and the class or classes of directors or employees to whom such shares are to be issued. So, according to Section 54 of the Companies Act 2013, a company can issue sweat equity shares of a class of shares already issued if the following conditions are fulfilled. Firstly, the issue is authorized by special resolution passed by the company. Secondly, the resolution specifies the number of shares, the current market price, consideration, if any, or the class or classes of directors or employees to whom such equity shares are to be issued. So, firstly, the company has to pass a special resolution. Secondly, it has to specify the number of shares, then the current market price, the consideration, then the class of shares which are to be given, or the class of people to whom these shares can be offered, whether it is employees, whether it is directors, whether it is managers to whom these shares are going to be issued. Then C, deleted by amendment of section of 2013. Then where the equity shares of the company are listed on a recognized stock exchange, the sweat equity shares are issued in accordance with the regulations made by the Securities and Exchange Board in this behalf, and if they are not listed, the sweat equity shares are issued in accordance with such rules as may be prescribed. So, where the shares of the company are listed on a recognized stock exchange, in that case, the sweat equity shares are issued in accordance with the regulations made by Securities and Exchange Board in this behalf, and if they are not listed, then sweat equity shares are in accordance with the rules as may be prescribed by the Act. Next, the rights and limitations, restrictions, and provisions are for the time being applicable to the equity shares shall be applicable to the sweat equity shares issued under the section, and the holders of such shares shall rank pari passu with other equity shareholders. So pari passu means same. So the rights and limitation, whatever sweat equity shares are issued to the employees or to the directors, to the managers, to whomsoever they are sold, the rights and the duties or the liabilities shall remain same as they are to the other shareholders of the company. Then next we have different terms for different terms of issue of shares. So there are different terms for the issue of shares. Shares can be issued at par, at premium, and at discount, but we cannot issue shares at discount. So now we'll study about shares issued at par. What do you mean by par? When the issue price of the shares is exactly equal to its face value, the shares in such case are considered to have been issued at par. That means a share having nominal or face value of rupees 10 is offered for rupees 10 only, and a lottee pays rupees 10 only for such a share. As per SEBI's guidelines regarding public issue, certain companies must issue the shares at par, such as a new company, existing private company, or a company not listed in the stock exchange which has not consistently earned profits for the last 3 years. A new company set up by unlisted company without a 5 years track record. So, what do you mean by shares issued at par? Issued at par means whatever is the nominal value shall be the issue value. So, if the face value of the shares is rupees 10, it is offered for rupees 10, and the allottee to whom the shares are sold shall pay also rupees 10 only. And as per SEBI's guidelines, issue at par is generally done by a new company or existing private company, or a company which is not listed on the stock exchange and uh, and has not consistently earned profits for the last 3 years, or a newly set up unlisted company without a 5 years track record. So these are few of the terms or few of the conditions in which issue of shares at par shall be done by the company. So basically, what does issue of shares at par mean? That selling the shares at the nominal or the face value with whatever is decided by the company. It can be 10 rupees, it can be 20 rupees, it can be 100 rupees. Whatever is the nominal or whatever is the face value of each share, they shall be sold at that amount only. Then next we have issue of shares or securities premium. If shares are issued at a price which is more than their face value or nominal value, the shares are said to have been issued at premium. A company can demand from the shareholders as a condition of allotment an amount higher than the nominal value. For such issue, there is no need to obtain any kind of sanction from the authority, but the SEBI guidelines are required to be followed. Section 52 lays down certain rules regarding utilization of the amount received as premium from the shareholders. Now, next we have issue of shares at premium. What does issue of shares at premium mean? Issuing shares at a value which is higher than the face value. Earlier we studied shares at par, now it is issue at premium. So if shares are sold at a value which is higher than the face value, suppose the face value of the shares is rupees 10 and I am issuing shares at a market value of rupees 15, so 5 rupees which is there is the premium over the shares. So whatever amount is issued over the face value is the amount of premium. The act has not provided any restriction on issue of shares at a premium, except for that the amount received as premium has to be transferred to an account called as securities premium account. So the company has not provided any restriction or anything. It says that the amount which is received over the face value shall be transferred to account saying securities premium account. So this is a issue of shares or securities at premium. And remember, when we issue shares at premium, it shows that there is a growth in the company or the company is gaining a boost in the market, hence the share value are increasing day by day. Next, we have the said securities premium account may be used by the company only for the following purposes. This we shall be starting from the next class.